The end of a marriage is always difficult, but if you and your spouse have children, the complications and ramifications can even be greater. The way that you and your spouse resolve issues concerning your children during the course of your divorce proceedings will have an immeasurable effect upon them for the rest of their lives. Studies have shown time and again that it is possible to minimize the negative and hurtful effects of a divorce or separation on your children by communicating and cooperating with one another. Even if you are only able to communicate and cooperate when it comes to the children, every effort should be made for this to happen. Your lawyer should explain the different variations of legal and physical custody to you at the outset of the proceedings. In many situations, you and your spouse will have to decide whether or not joint legal custody is an option for the both of you. Each state has different titles that they give to parents depending on the parental rights and the duties that may be assigned to them. Joint legal custody essentially means that all major decisions affecting your children, including medical treatment, educational decisions, religious issues, mental health, and other important concerns, will be discussed and decided upon together. Unless specifically stated in your agreement, neither of you will have final say, and the two of you must agree upon all of these major decisions and considerations. Even in a situation where the two of you share joint legal custody, in some states, it is common for one parent to be the primary residential parent. Some states avert attention from titles and look at actual time with the children in decision-making duties. This means, essentially, that although the physical time the children spend with each parent may not be equal, both parents, because they have joint legal custody, maintain all of the rights that go along with that legal status. In addition to rights, there are significant obligations that each of you will have if you agree upon joint legal custody. It is assumed that when the two of you reach an agreement on joint legal custody, that you are able to communicate and effectively cooperate with one another when it comes to your children. In order to have an effective joint legal custodial arrangement, both parents must be ready, willing, and able to deal with one another, in part by keeping an open line of communication at all times. This assumption is extremely important and is the cornerstone of joint legal custody. You can be creative with regards to custody and the physical access both parents have to the children. You can be flexible with regards to the schedule of the access that both of you will have to the children depending upon your job demands, lifestyles, and personal preferences or desires. While weekend and midweek contact with the non-residential parent is typical, you may want to consider maximizing the amount of contact that the children have with both parents. All orders are subject to the court approving them. Remember, courts and experts believe that it is the best interest of the children to have two parents, even in a divorce or separation situation. This basic principle will impact any decision that a court has to make regarding your children. Remember that children are not assets to be divided. Dealing with them in that way will surely maximize the pain they must withstand throughout the process and perhaps even long after the divorce or separation process has been completed. If the parents cannot agree on custody, the court will make the custody decision for them based on the best interest of the children. The court may award one party sole custody or may order joint custody. If one party is awarded sole custody, the parent may not be required to consult with the other party concerning issues involving the children. Sometimes, a judge will appoint a law guardian or a lawyer whose job is to represent the interests of the children, yes, another stranger. It is also possible in some situations that a judge will appoint a mental health professional to conduct a forensic analysis of the family to make certain recommendations to the court regarding custody and access to the children. In many cases, judges count on their professional experience and the training to assist them in making a determination regarding custody. The forensic process is also fraught with pitfalls. Yet, while far from perfect, it is the only real way that a court can try to get inside the family's dynamic. Most judges and lawyers will tell you that once you embark upon a litigated custody case, the effects are quite damaging and sometimes irreversible. Imagine having your children interviewed by the judge or by their own lawyer. Imagine further that the children may, depending on their age, be subjected to meeting with a forensic professional to be interviewed once, if not several times. Picture the custody trial as you take the stand to testify against one another and call witnesses against one another. Aside from being unpleasant, a contested custody trial can permanently damage your ability to communicate with the mother or father of your children. The bitterness of such proceedings has a far-reaching impact. You must ask yourself if such an undertaking is really in your child's best interest. An issue that frequently arises with regards to custody is if one parent wishes to relocate with the children. This is called a relocation or move-away case. There are many considerations that courts could consider when deciding whether a parent can relocate with their child or children. Some of these considerations are as follows. The impact of relocation on the quality and quantity of a child's future contact with non-relocating parent. The degree to which the relocating parent and the child's life may be enhanced economically, emotionally, and educationally. The feasibility of preserving the relationship between the non-relocating parent and the child through suitable visitation arrangements. The potential to maintain family relationships, the child's or children's preferences depending on whether he or she is of a certain age, the opportunities affecting the child or children, the age and health of the child or children, and the location of the parents' residences, and consequently, the opportunity for visitation are also taken into account in this process.